All right. Well, good afternoon, everyone, and welcome to the POGO's webinar discussion event on Supreme Court ethics or lack thereof. Thank you for joining us, and we are so pleased to host this conversation. My name is Sarah Turberville, and I direct the Constitution Project at POGO. At POGO, we seek to expose when the government engages in corruption and abuse of power and seek solutions that will better ensure the government hews to constitutional principles. So why are we talking about Supreme Court ethics? Well, first, the Project on Government Oversight, we have a long history of seeking stronger ethical guardrails for both the executive branch and the Congress to ensure that the government works for all of us, not just the powerful. This mission naturally then must focus on the highest court in our land. The judiciary is meant to serve as a check on the other branches and as a safeguard where individuals can seek redress for when the government violates their rights. But what happens when the justices of our nation's highest court, the one where 9 people in government hold their positions for life, act without regard to ethical constraints? Can the public have faith in this institution when its members act with something that begins to look a lot like impunity? And as some members of Congress have asked, should our highest court be held to the lowest ethical standards? So our 2 panelists are here today to break down the ethical crisis that seems to be enveloping the court, answer your questions, and maybe even help us carve out a path to something better. So let me introduce them now. First, I'm pleased to introduce Professor Charles Geyh, or Charlie. Charlie teaches and writes in the areas of judicial conduct, ethics, procedure, independence, accountability, and administration at the Indiana University Maurer School of Law. He's authored many books on the subject and has served as an expert witness in the Senate impeachment trial of federal district judge Thomas Fortis. He was assistant special counsel to the Pennsylvania House of Representatives on the impeachment and removal of Pennsylvania Supreme Court Justice Rolf Larsen. He's been a consultant to the National Commission on Judicial Discipline and Removal, legislative liaison to the Federal Court Study Committee, and has led multiple commissions on the judiciary sponsored by the American Bar Association and other organizations. David Janovsky is an analyst with the Constitution Project on the here at POGO. David researches and develops policy reforms on separation of powers issues, particularly involving Congress and the courts. He has authored several articles on judicial ethics and was a primary drafter of POGO's 2023 Model Code of Conduct for the Supreme Court and our 2021 report, Above the Fray, on structural reform at the Supreme Court. David has also worked as a research assistant at the Harvard Kennedy School of Government, where he contributed to an analysis of the response to the Boston Marathon bombing. All right, well, with our intros out of the way, I just have a couple logistics before we dive in. The first is that this is a conversation, not a presentation. And we'll structure this so that I'll ask a few questions to get us started, and then we'll turn pretty quickly to our audience for their questions. And I know that many of you have already submitted some, and so I'll be asking those as well. If you'd like to ask a question, just post it into the chat, and we will, time permitting, do our very best to get to it. And in the chat, you will also find some resources that we'll be sharing throughout the course of the discussion. There'll be probably testimony we reference or articles or reports, and we'll make sure that you have access to all of that as well. So why don't we go ahead and get started? And with that, I'll turn to David and ask, maybe you can explain to us why we are talking so much about Supreme Court ethics right now.
Thanks, Sarah. Let me answer that by giving both a broad answer and then a more specific answer. Or actually, I'll start specific. We're here today because, and we've been talking about ethics a lot in the last few months, primarily because of the news about Justice Clarence Thomas, most notably his lack of disclosure of quite valuable gifts that he received from someone who's otherwise best known as a political donor, Harlan Crow. This has been pretty big news. It's one of the more significant ethics failures we've seen at the court in recent years, and it's a story that seems to continue to develop. So that is the short-term impetus. But the bigger picture, and I think this is important context here, is Clarence Thomas is not the beginning and the end of the story of ethics at the Supreme Court. And really, it's important to remember that this is a systemic problem, and there have been examples from across the ideological spectrum, from every justice who's served in the last decade or so, of instances where their ethical conduct was not quite as sharp as we would have liked to see it. This can be Justice Kagan not recusing from the Obamacare decisions, despite her involvement in the Solicitor General's office. This could be Stephen Breyer's ownership of individual stocks, which is a problem Justices Alito and Chief Justice Roberts have run into over the years. Justices have taken large book deals after joining the bench. So I think it's important to both keep in mind that the specific news that brings us here today is very significant and important, and also that it's not an isolated event. And this is, at the end of the day, an institutional problem that's going to need an institutional response.
Thanks, David. Before I turn to Charlie, I wonder if you might be able to put a finer point on the specifics, or maybe as best you can, summarize some of the concerns about the conduct that was revealed in ProPublica's story about Justice Thomas in particular. Of course, Pogo, we filed a complaint actually with the Department of Justice, and I would like to say that I don't think that that's something we would do unless there was quite a bit of sort of concern and evidence that was backing up the filing of that complaint. So maybe you can talk about that for a minute.
Sure. So among the specifics, and there are a few different pieces of this, so this may not be comprehensive, but most notably, Justice Thomas received personal hospitality from Harlan Crow in the form of luxury vacations being hosted at luxury resorts owned by Harlan Crow and some of his personally held companies. Another particularly vivid example is that Harlan Crow actually purchased Justice Thomas's childhood house, which is where his mother still lives, with plans to eventually turn it into a museum about Justice Thomas. And so the receipt of the personal hospitality, I think, in itself raises questions, especially because of the really high dollar value attached to this. We're talking in the hundreds of thousands of dollars, including private jet travel and yachts and that sort of thing. More concretely, this was a problem because a good chunk, if not all of these gifts, should have been disclosed under the financial disclosure and gift rules that are in place for the federal judiciary, including the Supreme Court. While personal hospitality is sometimes exempt from the reporting requirements, which come from the Ethics in Government Act, transportation and things that come from corporations are categorically exempt from the exemption, which is to say they are required to be reported. And so a number of these gifts fell under that category and were not reported, which is the basis for Pogo's complaint to the Justice Department, which is ultimately in charge of ensuring that the Ethics in Government Act is followed.
Thanks, David. Charlie, I'm going to turn to you now. And you know, you have been studying this issue for some time, and I wonder if you can bring the current crisis into sharper focus for us. How did we get to this point where we're talking about, sort of merely talking about failures to disclose under a 1978 law as kind of being the outer limit of the ethical framework that seems to govern the Supreme Court of the United States?
I think about it in terms of sort of short frame answers and sort of more deeply historical answers. The short frame answer, I think, is that one of the things that codes of conduct do for the 25,000 other judicial officers that are subject to them is create a kind of culture in which they promulgate the rules, they revise them, they think about them, they internalize them. It's sort of, it's akin to part of the air that they breathe. They live a code culture. And so the kinds of gifts that David just described are the kinds of gifts that judges would ordinarily look at and say, oh my God, that's just not within the scope scope of the sort of thing I would think about taking. So I think there is this problem where the Supreme Court, although they say they sometimes look at what the code applicable to the lower federal court says, that's just not the same thing as having a code that you internalize and live, eat, and breathe. The other part of it, which is the more historical point, is that this has been a long time in coming. I think in some ways, David's examples run the gamut from soup to nuts, from what I would regard as venial sins to much more serious misbehavior. And to my way of thinking, the most serious misbehavior is really attributable to the court becoming a much more partisan body over the course of the last generation. And that began during the Reagan administration, when the Reagan administration was frustrated, I think, by the fact that the Burger Court had not reversed course from the Warren Court to the extent it should, and really embarked on a program embedded in an Office of Legal Policy memorandum to the effect that we want to change the direction of the Supreme Court via a systematic appointment of ideological conservatives. And so beginning with the nomination of Robert Bork, it was game on. And both sides start ramping it up until it becomes a very partisan affair in which the judges really are selected with their ideological composition in mind. And they're, I think, a much more political body than they once were in that sense. And so if you look at the kinds of problems that the justices are getting into that I regard as more serious, there really is kind of a partisan cast to them. The one that David mentioned, one of two that I think of with Justice Thomas. The other has to do with his non-disqualification from a case in which the issue was whether to honor a subpoena disclosing Trump documents from the January 6th to the January 6th commission, which included documents generated by his wife and where he did not disqualify himself. A clearly sort of partisan cast to that. Shortly before that, Justice Ginsburg was openly criticizing candidate Donald Trump in violation of the code of conduct. Prior to that, Justice Scalia and Justice Thomas were both participating in as key featured speakers in Federalist Society fundraisers in violation of the code. You have somebody releasing the Dobbs opinion, probably a justice, and that is ideologically and partisan motivated. I think that a lot of these developments, I think some things are less partisan than others, but some of the most serious are, and you're dealing with a different kind of court that is really, I think, agitating both sides, and so more focus is being turned on it, and it brings us to where we are.
So, one thing I've heard as we have been doing a great deal of advocacy around Supreme Court ethics reform is that somehow imposing a code of conduct on the court or trying to strengthen their obligations to disqualify in cases when they have a financial conflict or some other kind of conflict of interest is like a proxy for just trying to get justices that you don't like to be disqualified from a case. And I'd love for both of you actually to speak to that a little bit. And because I feel like one of the things that's missing from this conversation is an understanding of what the paltriness of the existing framework that governs the conduct of Supreme Court justices, and how does it differ from other courts and other judges in the country. So how about we'll let Charlie take the first stab at that, and then David.
Sure. I think that the point I made earlier was that every other judge in the United States is subject to a code of conduct, except the Supreme Court. And I was thinking this morning, I was thinking back to my days as counsel of the House Judiciary Committee in the late 80s, early 90s, where, our working relationship with the Republicans was very good. And this kind of reform, making sure that judges thought about, that the justices thought about their ethical obligations, that they took them seriously, that they had a code that they would agree to follow, would simply be regarded as good government legislation. There is no way that you can stop angry liberals and angry conservatives from weaponizing codes of conduct and going hunting. You can't stop that. But that is a separate and distinct problem from the issue of, is this something that we want good judges to think about? It's not really, the point isn't to go hunting. The point is that every other judge in the country is looking at this, is thinking about this. Why shouldn't the Supreme Court? I think it should. And the fact that you're going to have squirrely little guys on both sides using this for nefarious purposes is beside the larger point of why we need a code of conduct for all judges.
David?
In addition to agreeing with all that, I'll just highlight a couple other things that the Supreme Court doesn't have that, the rest of the federal judiciary has and that the other branches of the federal government have. And that's kind of the broader ethics infrastructure. For the lower federal judiciary, the judicial conference has, whether or not it works perfectly is an issue I'll set aside for the moment, but, has committees that look into ethical decisions. There are ways for recusal or non-recusal by lower federal judges to be reviewed higher up the chain. The executive branch, Congress have full-time ethics staff whose job it is to counsel officials on when they should step aside from a matter that may come before them, or to make sure that their financial disclosures are in order. And by and large, that infrastructure just doesn't exist for the Supreme Court, largely because the court has said it would be inappropriate for the mechanism that serves the lower courts to have actual authority over it. And we can, I suspect, get into that question much later, but for now, suffice to say, they don't have the same kind of infrastructure supporting their ethics decision-making.
I'd like to talk, there's been a question that came in before we started the program today about what reforms are on the table. And so I'd love to hear a little bit from both of you about, what you view to be maybe the most important components of a code of conduct for the Supreme Court, or what you view to be the most important thing for maybe Congress to be requiring of the court, or potentially, other parties that are involved in judicial selection and trying to influence the court. Charlie?
Sure. In terms of the content of the code, the answer is easier than you might suppose. That in 1972, the American Bar Association got together with a commission and promulgated the ABA Code of Conduct. The next year, the Federal Judicial Conference of the United States adopted a code of conduct for itself for the lower federal courts that was very closely reliant on the ABA model. And in the years since, literally all 50 states have adopted codes of conduct that look very much like the ABA model, either from 1972, 1990, or the most recent one, which is the one I served as co-reporter to in 2007. And so really, I think the operative issues aren't the content of the code, which is going to look a whole lot like one of these codes. It's really who should do it. In my perfect world, the judges should do it on their own initiative because it's the right thing to do. Every other jurisdiction in the United States, that's how Supreme Courts have done it. They've gotten together, they've done the right thing and done it. The second best choice is really for legislation to waggle the finger in the direction of the court and say, promulgate yourself a code. The third and least attractive one to me is the option of having the Congress devise a code, draft it, and impose the drafted code. And the reason I don't like that one as much is because it really doesn't allow for the court to internalize a code of its own making. And these codes are revised every couple of years. Legislation is not. And so I worry that if we had a code created, it would ossify, it would lock in place, it wouldn't address changing circumstances, it wouldn't be nimble enough. But I think that those really are the choices. Have Congress impose it outright, have Congress tell the court to do it, or have the court, step up and do it on its own.
Thanks, Charlie. David, I wonder if you can offer any additional remarks on what a code for the Supreme Court would look like, especially since you were one of our primary authors of our model code of conduct for the Supreme Court that we just happened to release about a week before the ProPublica story hit.
Yeah, we did not have advanced knowledge. So I think, Charlie's point is an important one. Like, there's a really good code out there that the court could snap its fingers and adopt tomorrow. But I think also sort of in the spirit of, it's good for these things to be updated fairly regularly, lest they ossify. What we were trying to do in the project you mentioned, Sarah, was using the existing code for the lower federal courts as a template, add some provisions that we thought might be appropriate for the Supreme Court, either because of circumstances that have changed since the federal code last went through a big modification, or because the Supreme Court is kind of uniquely visible, and that visibility has actually been shown through some pretty interesting research to trickle down on how the public perceives the federal judiciary as a whole. And so what we came up with in that code was a slightly more stringent set of standards for the justices that went to some more specific circumstances around their financial disclosure obligations. It urged more restraint from some of the public appearances before organizations that have a partisan cast, like the Federalist Society, like the American Constitution Society. It expanded some of the recusal standards to account for some of these maybe historically more novel financial entanglements that we're seeing now with justices, with their families, with parties lobbying the court in non-judicial ways, like through spending on the nominations process. So, we took this opportunity to say, how can we make an even stronger code that would really shore up some of the holes that we've been seeing over the last couple of years? And those, again, conduct, transparency, and a slightly wider net for recusal decisions would be our top priorities there.
Thanks, David. There's a couple of questions in the chat that are relevant to this. And one that we got beforehand, which is, and I'm going to pitch this to you, Charlie, because this is something you've written about extensively. Can Congress do this? Can it can it meddle in the conduct of Supreme Court justices?
Yeah, I think it can. I think the way you look at it is that there's a bunch of provisions applicable here. First is, it sounds like Genesis. In the beginning, there was no Supreme Court. That Congress was assigned the task of bringing a Supreme Court into being, and with the necessary and proper clause, adding, and as part of creating the Supreme Court, you have, basically legislative authority to do whatever is necessary and proper to bring this into being. In addition, Article 3, Section 2 gives Congress explicit authority to regulate the appellate jurisdiction of the Supreme Court, which frankly is pretty much all that the Supreme Court has these days. And finally, it seems a little obscure, but not really. The Constitution includes an oath of office for everybody. And in the years since, Congress has regulated ethics in a variety of ways. Dealing with the most obscure first, Congress has modified the oath that judges must take. And justices of the Supreme Court have to raise their right hand and swear to do equal justice to rich or poor, to be impartial. In other words, it's a mini code of conduct that judges raise their right hand and swear to. And so I think the idea that you can require them to elaborate seems like a perfectly fair thing. I think they've also applied disqualification rules to the Supreme Court in terms that are virtually identical to the terms that codes of conduct use. When Congress added those in 1974, they really borrowed heavily from the ABA model code of judicial conduct. And so you've got that as well. And then again, there's also what David was referring to, is that gifts restrictions are aimed at preserving or creating greater transparency that will expose judges when their impartiality, independence, or integrity are at issue. And so all of those really suggest that we have constitutional authority to regulate in this area. The one little quirk, and I at risk of getting a little too far into the weeds, so far at the previous hearing, Professor Lawrence Tribe and Judge Lessig, opposite ends of the ideological spectrum, were in agreement with me to this extent. In other words, they were in agreement with me that that Congress could create a code itself. They expressed doubts about whether Congress could delegate the task of creating a code to the judges. And the only thing I'll note there is I think that they weren't focusing on really the ways in which Congress has regulated the courts in the past. The Rules Enabling Act in the 1930s enabled Congress to delegate to the courts the task of making procedural rules, and the Supreme Court affirmed, saying, if you got the power to regulate this in this area, and you do, well, then you have the power to delegate the task of promulgating rules relevant to that to us. And Congress did it again with the disciplinary statute, where it delegated to the Judicial Conference the task of promulgating rules relevant to the disciplinary scheme. And so, if we agree, and Lessig and Tribe and I agree, that Congress has the power to regulate this in this area, the Civic case tells us that we have the power to delegate that task to the Supreme Court.
But on principle, I think that it seems rather clear that this is an area where the Congress does have constitutional authority.
We seem to be in agreement, yeah.
Yeah, and it's interesting. I think one of, and I'm just going to take a point of moderator's privilege here for a moment, but I think often there is a discussion about how lifetime tenure was something that was really vital to ensuring the independence of our federal judges and the Supreme Court in particular. And we can certainly have a separate discussion about that. But because these individuals serve in these positions for life, it would seem that really robust ethical safeguards are absolutely vital to ensuring the independence of the court. So it's almost like a must do in order to protect the independence of our judiciary. There is a question that has come in that I think a lot of people are wrestling with, which is that in some ways the Supreme Court is different, and that's really where the concern about enforcement of a code of conduct comes in. And so I wonder if, David, maybe you can be the first to take this question, but if a code of conduct is not enforceable, with the exception of maybe impeachment, what really is the utility in having a code?
So I think, as Charlie has said quite eloquently, there is value even in a sort of a quote unquote unenforceable or unenforced code in having the justices say, this is what we believe, this is the standard we are going to strive to act by. That in itself would be more than we've gotten now, which is a series of kind of grudging comments every decade or so from the Supreme Court saying, well, we look at what the lower courts do. Like, we think that's nice to look at. That is a step below sort of an affirmative statement of this is what we are going to strive for. Since this is something that comes up a lot when we talk about the lower court code as well, even the lower court code, which is a binding code of conduct, if you do something inadvertently or maybe even not inadvertently that may fall on the wrong side of the code of conduct, it doesn't mean a judge is automatically brought up on disciplinary proceedings in the Judicial Conference, for instance. It's more, again, this recognition that there is value in stating what your values are. Though in the lower courts, there is a mechanism for serious cases of judicial misconduct, which kind of by definition will fall on the wrong side of the code for discipline. And so you started the question with the sort of thorny issue of how do you judge the most powerful judges in the country? And this is not, one of the concerns I think is, will ethics reform somehow result in a super Supreme Court that is judging the Supreme Court, which would arguably be unconstitutional, at least if it was reviewing the decisions they were making on the merits. And so again, I think the first answer there is first to restate, even setting aside enforcement, there's value in having an ethics code. But there are also some enforcement provisions already in place. Obviously, impeachment is one, even if it's never been successfully used against a Supreme Court justice. There are provisions in the Ethics in Government Act, like the ones Pogo cited in our complaint, that on their face do apply to the justices, and that's never been challenged. So, that allows for civil penalties, presumably. And then there's a lot of legislation floating around at the moment that takes different approaches at having some sort of review or enforcement, whether that is empowering a panel of very senior lower court judges to opine, if not actually hold to account about the propriety of certain ethics decisions the justices make, or whether that's beefing up Congress sort of under the auspices of its oversight power to take a more regularized or proactive approach to reviewing issues that come in. So enforcement is certainly one of the harder things to address, but I don't think it's impossible, and it certainly shouldn't be an issue that holds back progress in other ways.
Well, I'd love to, in a moment, talk a little bit more about the other sort of ethics reform proposals that are out there that are outside of a code, but I do want to give Charlie an opportunity to speak a little bit to the question of enforcement and a code of conduct for this.
Yeah, I think that I'm in accord with what David says in the main. I think that the White House bill does call for a disciplinary process to be instituted vis-a-vis the Supreme Court. That one gives me pause. I think that in a perfect world, in a calmer world, in a less partisan world, the business of having Supreme Court justices subject to a process akin to what lower court judges are subject to, in which anyone can file a complaint. It goes to the chief judge. The chief judge evaluates whether there's any there. If there is, it goes to an investigating committee. If the investigating committee concludes that there's something to it, it then goes to an administrative body within the court that determines what the appropriate sanction ought to be, ranging from a private reprimand to a public reprimand to suspension to recommendation of impeachment. And I think you could see where, well, in the abstract, you could do that at the Supreme Court level too. The problem is that these are not normal times. And I really do fear that if we had a disciplinary process in place right now, every crank and his mother would be filing thousands of complaints against their least favored justice. They'd be swamped with complaints, and a process that was really intended to restore public confidence in the court would have the opposite effect, because it would look as though they're misbehaving at every turn. And so, the way I look at it is, let's stage this thing. That when the Judicial Conference adopted its code applicable to the lower courts in 1973, it was another 7 years before they had a disciplinary process. Let's see how the code goes. Let's see whether the court can, once it's in place, whether the court can start paying closer attention to its code, and we stop seeing as much of this nonsense, recognizing that some of these accusations, I think, are lightweight. In other words, some of these allegations against justices are make weight, and that will continue to be the case. But to my way of thinking, I think, having a lack of enforcement is a problem. But the enforcement mechanisms that are available arguably make the situation worse right now. I mean, the one thing that David didn't mention that I think would mention is the possibility for disqualification, at least, which has 1 foot in ethics and 1 foot in procedure, that creating a mechanism whereby the whole court could review non-disqualification decisions is, I think, a less problematic one than going after a judge with disciplinary sanctions and so on.
Certainly, and right now, I mean, there's not even a baseline from which to work, right, for the justices to be able to make consistent decisions on disqualification. Right. The guidelines are a little bit clearer if it involves, a specific financial conflict of interest, but really the criteria are rather subjective when it comes to non-financial conflicts, thinking about like Clarence and Jenny Thomas in the January 6th case, for example, cases. I'd love to to hear a little bit more about there's all these questions about constitutionality of Congress doing this or that, but like there's no question that the Chief Justice and the court itself could pull together a code of conduct for themselves. Why isn't that happening?
Couple things. One is the only one thing I wanted, one caveat to what you just said, sir. I did want to note that 28 U.S.C. 455 is pretty detailed in terms of the specifics for disqualification. I mean, there are a lot. I mean, I think you're right in saying that a lot of times you fall back on 455A, might the justice's impartiality reasonably be questioned. The reason I get hopping up and down about Clarence Thomas is there's a more specific provision, which is that the justice has to disqualify himself if he has an interest that could be, or his spouse has an interest that could be substantially affected. And in a case where she's at risk of being outed for all of her correspondence in connection with January 6th, to me, that was one reason for disqualifying. But that's really sort of, I mean, I just wanted to add that I'm not going to give the justices an out saying, well, it's unduly vague. I think that there are specifics in there. And now I've gotten so excited, I've completely blown off your original question, which was what? I mean, it was
why doesn't the Chief Justice head this off at the pass and have the court adopt a code of conduct?
Sorry about that. This is one of those things. I'm a boomer. My apologies.
No, I appreciate the clarification.
One of the, I mean, I think that in the beginning, in 2011, I think that there was a kind of arrogance associated with this, where the Chief Justice issued an annual State of the Judiciary message where he basically said, we don't need a code. We are following we check out the code. We basically consult the code applicable to lower court judges, and consulting isn't the same thing as following. I mean, a point I've made before is it's kind of like you can agree to consult your mother. That's different than saying you agree to do what she says. And I think that there is a difference here as well. Now, about 5-7 years ago, I was testifying before the House Judiciary Committee on this matter. And at that point, the word on the street was that the court was really thinking very, very seriously about adopting a code of conduct quietly and getting it done. And I think that what's happened since is that the partisan tenor of this has ramped up to the point where there are probably justices on the court saying, I don't want any piece of this because it will only be used to weaponize attacks against me. I think that's wrongheaded. I think that the code is, there's still going to be those attacks. It's just now, honestly, I think in many ways the code can exonerate judges. In other words, that these randomized attacks of isn't this looking suspicious are going to be set to one side if you've got a code with specifics where the judge can point to it and say, I'm following the code. But I think that we do have a partisan sort of real feeling that is stonewalling the court in its ability to actually get it done. And that's totally speculative. I'm just thinking that there seemed to be progress a few years ago that seems to have stalled out. And I'm thinking that they no longer have everybody on board.
First, I just want to say, I think that's a really good point that Charlie makes about the protective potential for a code. Because if, a justice does something that doesn't pass the smell test, but they can point to the code and say, this is fine. I mean, then we can all have a discussion about whether the code needs to be changed, but it's not a conversation about, the bad judgment of, Justice X. So, it is really disappointing that the Supreme Court seems to have lost momentum on that. And two developments that are worth pointing out this spring. One was very shortly before some of the latest reporting on Justice Thomas, there was a story, I think in the Washington Post, about how the court had sort of quietly folded its efforts to draft a code because they weren't able to get any consensus. I don't know if there was ever any formal statement about that, but it certainly seemed plausible given the other signals we've seen from the court. And one of those signals was a few weeks later, after some of the reporting on Justice Thomas came out, the whole court did actually issue a 2.5 page quote unquote statement on ethics, principles, and practices. And they brought out again this line that they consult the lower court's code. And then it kind of went off the rails. I mean, they talked about recusals in a way that, you know, they started this sentence, and this is kind of a pet peeve of mine, so if you'll indulge me for a minute. You know, they started by saying they follow the recusal rules that everyone else in the federal judiciary follows. And then they spent 2 paragraphs explaining why they actually don't, because they've decided that they're too important to not be able to hear any given case. And maybe if there's more time, we can talk more about some of the specific legal principles that say and mean one thing if you're a lower court judge, and apparently mean something completely the opposite if you're a Supreme Court justice. But they've let's say stretched some principles that encourage just judges to not, you know, duck out of hard cases that they may not want to hear, and kind of given them a weight to say that, oh yeah, we have an independent obligation, even if we have a conflict of interest, to hear cases. And that's just not the way the system's supposed to work. And the statement as a whole took more of that tone. They wanted to make it seem like they were beefing up their ethics rules, and really kind of undermining them at every opportunity. And so with that attitude from a unanimous court, which is not a rare thing these days, certainly not how we think of this court, that's a very bad sign.
Right, meaning all 9 justices signed the statement of principles that
correct.
was sent to the Senate Judiciary Committee.
Yes.
And just to clarify, that was a letter that was sent to the Senate Judiciary Committee after the chairman had asked the Chief Justice to come testify about Supreme Court ethics in light of the revelations concerning Justice Thomas. So I think there's certainly questions about whether or not the court is taking this seriously, and if they think they might be able to just wait this out the way they've been able to sort of wait out other scandals in the past. Charlie, there was a question in the chat about sort of the magnitude of the allegations concerning Justice Thomas, and if there's anything in history that sort of parallels, that's on par with that. And I wondered if you might be able to kind of give us a brief kind of rundown on on Supreme Court ethical lapses and misconduct, and where we're sort of situated now.
Yeah, I mean, I think that part of the problem in answering that question is that this current generation is the one that brings us, an information age where we have access to all kinds of information we didn't previously have access to. And I think that the point I made in my opening remarks about how uniquely partisan the court has become gets us to this business of judges fraternizing with mega donors as a sort of way of the world. I think it's consistent with the point I was making before of an ongoing effort 40 years in the making to change the complexion of the court, to sort of get together and create a court that is pivoting in a particular direction. And so that is something relatively new. I think that there are examples of pretty serious problems in the past. The one that comes immediately to mind is Justice Fortis, who, unbeknownst to others, was having routine ex parte communications with President Johnson about pending cases before the Supreme Court. It derailed his, it and other things derailed his nomination to become Chief Justice. And so I think that you've got those. I mean, the first impeachment in U.S. history was Justice Samuel Chase, and I think it usually stands for the proposition that judicial independence gets in the way of impeaching judges because of their decisions being unpopular. But I think if you read Justice Chase, he was a bombastic SOB. I mean, he used his dais as a bully pulpit for spouting political rhetoric. And it wasn't as a chief justice, it was in his capacity as a trial court judge, because at that point, justices on the court not only presided over the Supreme Court, but they then got on horses and rode around and presided as trial judges. And as a trial judge, he was engaging in what I think by today's standard would be intemperate behavior that was terrible. So we've got that kind of thing out there. But I think that what we've got right now is more information about more judges happening at the same time, and it is creating a focus that makes this an unusual one in our history.
Just to put an extra note on the Justice Fortis example, I mean, I think there were a lot of things swirling around, but ostensibly the straw that broke the camel's back and led him to resign from the court was something on the order of $2,000 he accepted to consult for someone who was under investigation. Which is an objectively bad look for a Supreme Court justice, and, you know, was dealt with. But I think it's notable that, you know, the last time we had a financial scandal quite like this, you know, someone left the court.
So what are the prospects for reform? What needs to happen next? What are the issues or the people or the dynamics that are holding up real judicial ethics reform at the Supreme Court?
Well, I mean, I can offer, you know, there are two avenues to reform, and both of them are pretty bumpy.
Talk about the Congress.
Right. Congress first. The Congress one is, you know, I was just looking, you know, I gather from yesterday's hearing that, you know, I was unable to testify, and I recommended someone to testify in my place. And as best I can understand, the Republicans on the subcommittee simply didn't show up in large part. I mean, I don't know to what full extent that is so, but as long as this is portrayed as a completely partisan issue, I think it is going to be very hard to get the traction we need. I mean, ironically and sadly, I think that if one of the liberals on the court got themselves into one hell of a mess, and the Republicans jumped all over it, that would get us where we need to go. And honestly, I think this is, David was sort of poking at this a little bit before. This is a game the whole family can play. I mean, it's not just about conservatives. And I was in the media being critical of Justice Ginsburg when she was openly criticizing Donald Trump as a candidate in derogation of the code. And I was also saying some, you know, sort of saying it's problematic for not just only Justice Barrett, but Justice Jackson, when they're accepting a book contract for multiple times their annual salary, as soon as they join the court. I mean, they're basically cashing in. It's not great. I don't think it's a mortal sin, but it is a problem. So I think that part of it is that unless and until we can really understand that this is a bipartisan issue with bipartisan concerns for justices across the spectrum, we're going to just sort of see us hunker down in our silos and getting nowhere. But I am hopeful that, you know, that will change as as developments unfold, for better and worse.
David, maybe you could speak to a couple of the legislative vehicles that are out there right now.
Sure. And first, I just really want to underscore the point. I mean, there have been a lot of hearings on judicial ethics over the last 3 years or so, and there's been sort of a steady partisan degradation in each one. So in some ways, it's sad to say that I think a partisan boycott of the last one in some ways probably made that a more temperate hearing than some of the more recent ones we've had. And, you know, we hear examples that, you know, because other justices have done things that are problematic in the past and nothing was done, then we can't do something now because it would unfairly single out. And again, it's Congress logic that two wrongs mean we can't fix it rather than two wrongs mean we need to fix it. With that said, there are some pretty neat bills out there in Congress, and hopefully someday some of them will get a little more traction than they have right now. But we have both Senators Sheldon Whitehouse of Rhode Island and Elizabeth Warren of Massachusetts with fairly comprehensive judicial ethics packages. They take different tacks, but they both do try to approach some of the same, recusals, financial conflicts, adding some of that extra review that Charlie was mentioning to recusal decision-making. So, those are both worthy bills that are worth serious discussion. And, I don't know that there's a perfect vehicle out there right now, but I really want to see the ball keep moving. There are also, smaller bills that would address other dynamics that I think feed into the politicization of the courts, whether it's, trying to rework some district court procedures or really narrowly tailored things about financial disclosure. We saw that one example of that actually passed last Congress, requiring judges and justices to more regularly report stock transactions because there was a problem of judges, probably by mistake, overlooking financial conflicts based on their stock portfolios and then hearing cases. So there are a lot of ideas floating out there, and I hope that the conversation continues to explore them.
I should just sort of punctuate the point by saying part of what's been folded into this legislation includes proposal to, for lower court judges as well as Supreme Court judges not to have the first and final say over their own disqualification. And if you think about that from a partisan perspective, it is very hard to see where there is a partisan cast to this notion that, judges shouldn't grade their own homework. They shouldn't be the ones who resolve their own disqualification because, if you have a problem, which is a judge is too biased to sit, who's the judge you take that to? The judge who's too biased to sit. And that just makes no sense. The oldest disqualification rule in the book is back in 1609 in Dr. Bonham's case, which said a judge shall not be a judge in his own case. But if you think about it, judges are judges in their own case every time they rule on their own disqualification. That's part of this legislation. And I struggle to see where that's a liberal or a conservative thing. That's a thing. And so consistent with David's point, I think that there is, if people can just calm down, there are opportunities here to do some good.
And it was only 1 or 2 Congresses ago that we had Republican-sponsored bills that, in various forms tried to strengthen the ethics rules for the court. And so I'm certainly hopeful that, if everyone took a breath, or as Charlie says, if someone else finds themselves in hot water and some of the more partisan calculations shift, like maybe we can get back to that world not too long from now.
Mm-hmm. I see a question in the chat about why are we worried about a perfect vehicle if there's little likelihood there will be substantive reform. And I just wanted to comment on that for a moment as one of the folks who's been involved in the advocacy around various bills. And I think part of what we have to work toward is even getting our allies to work a little bit more in lockstep. Because, unfortunately, it is primarily like members of the Democratic Party who are leading this effort. But I would not say that those folks are necessarily sort of working in tandem with one another. And so I think that is part of what we have to overcome here too, is to just kind of get out of our own way a little bit. There's also been a question about a related issue to judicial ethics, and that is concerning the amicus practice before the court. And for people who aren't familiar with that, when a court is considering, and we'll use the Supreme Court as the example here, when it is considering whether or not to take a case, or if it is decided to take a case and is going to decide it on the merits, interested parties that are called friends of the court or amici can file briefs to offer a view or perspective to the court. There is now just a robust amicus practice, I would say, before the Supreme Court. POGO is one of the entities that does file an amicus brief from time to time as well. But it certainly raises the question about how outside groups are seeking to influence the justices, so that there's something going on beyond the information that is presented by the parties that are before the court. And David, I wonder if you might talk a little bit about, kind of what sorts of efforts are afoot out there to address this particular issue.
Sure. So one option is, to increase transparency, and some of the bills that I mentioned already would require more disclosures by parties who file briefs before the court to, reveal maybe some of their major donors, or just provide more information about who's running the organization, because it's quite hard to tell much about in amicus other than the lawyers representing them just from current filings. But this is also a question we wrestled with a lot a few years ago when we put out a report called Above the Fray, which was seeking to take a more holistic look at kind of turning down the temperature around the Supreme Court, which included ethics reform. But one of the things we came up with in the course of that research is, transparency may be valuable. It wouldn't be bad to know more about parties before the court, but it's also very hard to legislate our way out of the enormous system-wide pressure around getting the Supreme Court to act in certain ways. All the things Charlie has been saying about the politicization of the court. There is a massive pressure from anyone who has an interest in policy, basically, to get the Supreme Court to rule the way you want. And I think ultimately, cutting back on some of these outside groups' efforts is going to require other, more fundamental ways to lighten those pressures on the court as kind of the final arbiter of policymaking in the country. And as much as I'd like to go into details, it's probably the wrong topic for the last 3 minutes of this conversation. But it has just showed up in the chat. So
well, yeah, we did
read that report.
Yes, and one of our audience members asked of Above the Fray which of the recommendations we thought were most important. And we'll certainly say that there's some pretty significant structural reforms that are recommended in that report, including
or at least explored.
What's that?
Or at least explored.
Explored, right. Including creating Supreme Court term limits, for example, having the court sit in different ways so that you don't have a predictable sort of bench of 9 people every single time, and maybe moderately expanding the court for that purpose so that it can sit the same way that other courts across the country sit, and other constitutional courts and other democracies sit as well. So we've got 2 minutes left. And I'd love to give each of you 60 seconds to sort of say and explain anything that you feel like we might have missed in this discussion that you think it's important for folks to hear. I'll start with you, Charlie. Oh, I think Charlie might be frozen. In which case, I'll turn to you, David.
Hopefully we get Charlie back before the end. I actually just wanted to take the chance to respond to one other comment that just came in about a line from that Roberts ethics statement about the risks of the justices gaming the outcomes of cases if the whole court were allowed to review recusal decisions. And I would just posit that should make us all very worried about the health of the court. I think it would be inconceivable that all 9 justices until very recently would have signed a statement like that, because historically the line is the justices all respect each other. The justices are all concerned with the law. They do not allow personal or policy preferences to invade their decision-making. So if this has become their best argument for, the status quo and not having even their colleagues consult on recusal decisions, I think we should be very concerned. And I also don't think we should take that as the final word on whether or not we can do some of these ethics reforms.
Thank you, David. And I think Charlie has rejoined us.
I don't know what happened, but I just disappeared into the ether. Is there a question on the table, or are we just closing?
We're closing in and wanted to give you just, maybe 30, 60 seconds to share anything that we didn't get an opportunity to.
No, the only point I'll make is to quote from New Jersey Chief Justice Arthur Vanderbilt when he said that court reform is no sport for the short-winded. I think it's relevant to what you were saying earlier, Sarah. The Rules Enabling Act, which was the act that enabled us to have the federal rules of civil procedure that delegated to the courts the task of rulemaking for the rules that we follow in the federal courts, took 50 years to get done. And I am, God willing, it's not going to take that long here. But I think that the fact that we're frustrated, the fact that we're at an impasse, I think needs to be viewed against the backdrop of history, that the average piece of legislation takes a long time to process. Things aren't looking great at the moment, but I think that things can change very quickly. And so I think it would be ill-advised to say, well, because we're frustrated that we should just throw our hands up and move on. That's just not the way of court reform.
Well said, and a great place to leave us, Charlie. Thank you.
Absolutely.
And I just want to say a huge thank you to everyone who joined us this afternoon, giving us an hour of your time, and especially to Professor Geyh and to my colleague David. This has been a wonderful discussion. And if folks want to learn more, please go to pogo.org. And we've also got, of course, all the resources in the chat as well. Thank you so much.